All right, welcome back, everybody. Thank you for joining us. Just really quickly, don't forget, visit chalkandgavel.com. Check out our merch. You can support the show there. We've got a great database of all 70 whatever of our episodes that we have so far. You can check that out. Go onto your social medias, like, rate, review, or obviously your favorite podcast platforms as well to like, rate, and review the show.
Support the show so we can afford a better studio.
That's right, a better studio, because here we are once again at a conference recording an episode in a hotel room with an ironing board propping up this camera.
So only the best.
That's right. Anyway.
But speaking of social media,
yes,
I've got a question for you.
Okay.
We're starting to see some real consequences of excessive social media use, especially for kids. So here's the question. Who should pay when those consequences show up at school?
Who should pay? I love it when he asks me the easy questions, who should pay? So I would say my student's favorite answer is it depends.
All right, that's the episode.
There you go. Some would say that the social media companies should pay. Some would say that the parents should be held responsible. Some would say that Apple or the device manufacturers should be held responsible. And some people would probably say that, like, Mark Zuckerberg and his friends should pay out of their own pockets.
Sure.
But regardless, once again, schools are where society plays out its biggest problems, right?
Right.
And so schools are kind of caught in the middle of this one, all right? They didn't sign up for this stuff. They didn't want to be in the business of solving the world's problems. But here we are. So
here we are.
So today, this is an interesting one. We've talked about this one on a number of bell ringers. So this is the lawsuit that is alleging that all of these social media companies have like Meta, which is Facebook and Instagram and TikTok and YouTube and Snapchat, that they intentionally design their platforms to be addictive to minors. All right. And that causes mental health issues and a whole host of other issues. So as this lawsuit reveals, the whole social media mess has been playing out in schools big time, and schools are a major part of this lawsuit.
Right. They're alleging that they've been left to pick up the pieces of all the harm caused by these social media companies, because it plays out in schools.
Right, exactly. So this today, we're going to give it the full Chalk and Gavel episode treatment. The full Talking Cattle episode.
The full Chuck and Gravel treatment.
To kind of dig into this. So this is the case of, wait for it, stupid name incoming. In re social media adolescent I screwed it up already. In re social media adolescent addiction, personal injury, products liability, litigation.
Yeah, it's descriptive.
It just rolls off.
Yeah, I don't think courts are naming their cases to be podcast episode titles.
No, we got to work.
Maybe that should be the title.
All right, welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one silly named case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, telling the fascinating stories, connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright. So the kids are alright.
All right, welcome back, everybody. Chris, bell ringer.
I've got a bell ringer, and this is another update on a case we've talked about a bunch that is also related to the Supreme Court shadow docket decision in Mirabelli that we just covered.
Oh, yeah.
So that was the one where California had a law preventing schools from notifying parents about their child's gender transition at school.
Yeah.
Got all the way up to the Supreme Court on the shadow docket. Supreme Court said that likely violated parental rights, both parental rights generally and parental free exercise rights, religious liberties.
Yeah.
And if you'll remember, one of the dissents in that case basically said, hey, maybe we should wait to do this on the merits and not do all of this on the shadow docket, because they had a couple of cases pending before the court that they could take up to answer that question.
Okay.
And one of those cases was Littlejohn versus Leon County.
That sounds familiar.
We covered in episode 36. So we're ahead of the game. Feels good.
That was like half of our lifespan ago.
It was a year and a half ago. Yeah.
That's crazy.
I know. We've got a lot of episodes.
So what did they do with that Littlejohn case?
Yeah. So that was the case.
That was Florida, right?
It was Florida.
Yeah.
It was a gender support plan that these parents were challenging because the school and the child created the plan without parental inputs.
Yeah.
And they were basically saying that creating that plan without their input violated their parental rights. And the school won at both the lower court and the appellate court. And so it got appealed all the way up to the Supreme Court. And the Supreme Court, given this opportunity to answer the parental rights questions on the merits on the official docket, did what?
Nothing.
They decided not to take the case.
Yeah. Oh, boy.
So, we never know why the Supreme Court doesn't take a case.
Yeah.
You have to have 4 justices to take a case. It could have just been the wrong case, the wrong facts, the wrong time. They might just not be ready. They might want to let the issue percolate a little bit more in the lower courts. Or, I've heard justices say that there's always going to be another case. And, these are lifetime appointments, so they're kind of not in a rush. Yeah. Like, there'll be another case that they could take to decide these questions. So maybe let it play out a little bit is the strategy.
Okay.
But it does make the shadow docket decision in Mirabelli that much more interesting.
Because they decided, there's no need to wait on that one.
Right. And
let's just bypass the whole darn process.
Right. But shadow docket's decisions don't create law. They don't create precedent. So like all of that reasoning that we talked about in Mirabelli, like that is, we can read it like tea leaves.
Yeah, because it provides a road, even though it doesn't create the law,
right.
It provides the roadmap for the next time another case comes through.
Right, yeah. So basically it leaves us in this odd spot where we have to kind of like divine the future because they haven't said it on the merits, but they've kind of alluded to which direction they're thinking about going in that case. Mm-hmm. So, it's another kind of situation where we're a little bit in limbo right now.
Yeah. Chalk and gavel, everybody. Your crystal ball into
We're doing the best we can with what we've got, guys.
Oh man.
So yeah, there's your bell ringer.
Okay. Well, they didn't take that case up.
That's right.
All right, but they took up Mirabelli on the shadow docket. So the short version is just keep tuning in every week because it's constantly changing.
And we'll talk about it again
next week. All right, so let's get into this week's episode, social media. This is a big one, everybody, so buckle up. We're talking about this decision. There's tons of ongoing litigation, all right? So this isn't decided. This is litigation involving lawsuits brought by school districts and other local governments against these social media companies. It's huge in terms of both significance and scale. Okay, because at this point, many of the various individual lawsuits have been consolidated into a single massive, what is called MDL, multi-district litigation.
Ooh,
yes.
Let's do with the acronyms.
Yeah, you like that?
Yeah,
I'm learning.
Somebody did their homework.
I listened to Chalk and Gavel. So multi-district litigation, it's like it's kind of like a class action in a sense where a whole bunch of lawsuits kind of come together because it's the same people are being attacked, or not attacked, but the same allegations against the same.
Yeah, there's a common core of issues and things like that, so it makes just kind of for efficiency.
Yeah,
decide them all.
Right, but the difference between that and the multi-district litigation is in class action, everybody comes together, they make one big decision, and then people get pieces of the pie get split up. Right. This one, it all comes together in the middle part where they're playing out the facts and everything, and then it goes back out to these individual lawsuits.
Right. To determine liability or application, and then whatever remedy is necessary.
Right.
Yeah.
And I'm only telling you all this. One is because it's important to be informed, but the other reason is because over the last few months we've seen a lot of those individual cases start either getting settled or like
Right.
some big payouts, millions and millions of dollars, that these social media companies are having to either through settlements or through court decisions are having to start paying. So this is all kind of coming together now, which is why we're talking about it. Okay, so I think we started to talk about it briefly in episode 12 when it was all kind of coming together. That
when
was like 2024.
Like when Seattle filed one of the first lawsuits.
Right,
Yeah.
right. So they're all moving along now, and the implications here are massive. These school districts are alleging that these different social media companies all acted to target young people and make their products as addictive as possible. Okay? So we know, like research has shown, that social media platforms design the choices that are associated with compulsive use and negative effects for minors. The argument is that they did this on purpose to maximize their reach and their impact with young people. Or at the very least, they knew about the negative consequences and leaned in anyway, or didn't do anything to prevent them.
Right.
Okay? And the schools point to a range of intentional design choices meant to drive engagement among users, things like weak age verification and parental controls, no meaningful limits on use, features that encourage constant scrolling and comparison, and systems that push notifications and high engagement content to keep students on the platform and locked in.
Yeah.
Right?
These products were designed for young people to use and to constantly use and to constantly be brought back into it to maximize time on screen or time in product.
Right.
Which I'm sure they have an acronym for.
I'm sure. Yeah, let's find it. So, and all of that stuff results in, mental health issues, antisocial behaviors, lethargy, just like a whole bunch of mental health problems. So lots of bad things. So what does this have to do with schools? The schools argue that they've been left to pick up the pieces, as Chris said before. All right, things like having to deal with stricter phone policies, increased counseling and support services. I mean, hey, you talk to a school counselor, and I'm sure you'll get an earful about what social media is, how that's playing out in schools. Right.
Bullying, harassment,
totally,
like just the peer relationship stuff.
Yeah. And so, if all of that isn't bad enough, the schools are saying that social media companies have specifically targeted school-aged children and schools, all while knowing about all of these impacts, right? So I'll give you one example. In a meta report, they said that, quote, research indicates that we have Facebook and non-Facebook high schools. Tipping schools may be high impact. And, quote, in the United States, per high school adoption is a crucial driver of teen Facebook engagement. Unquote.
So they're like...
They're directly saying...
It's a snowball thing. If we get people at the school to do it, more people at that school will be engaged with our product.
Yeah.
So
so let's go for the schools.
So they're not just targeting... Yeah, they're not just targeting kiddos. They're targeting schools.
Kiddos in schools, right? Yeah. So another report, Meta conducted a school analysis and concluded that, quote, Facebook high schools with greater than 75% adoption have 22% more TS, which is time spent.
Oh, there's the acronym I was looking for,
Per MAP, M-A-P, monthly active person. Okay? Oh, yeah, boy.
Okay.
Oh, yeah.
I'm with you.
Yeah. All of this is basically saying, listen, if we go hard in these schools and targeting these school-aged kids, then we're going to get a lot more
people
traffic.
are going to use our product more often.
Right.
Yeah.
And so I would say that's pretty damning evidence.
Yeah. And it doesn't surprise me that these corporations have these kind of metrics. And of course they have acronyms for it because, we're in education, we have an acronym for everything. But yeah, like this idea of if we get a critical mass at a school, that'll lead to more time spent, more users per month or whatever. So it does seem like the schools might have a case.
Yeah, I think so. So anyway, that's kind of where we stand with all of this. And, as I said before, we're, I think March, April, May, June of 2026, like we're starting to see a lot of these, some settlements.
Right.
And I think a lot of it's coming out of California. millions of dollars.
Yes, and that's because of what we're going to talk about today, or in part because of what we're going to talk about today.
Yeah.
Because the court, in the consolidated cases, decided some motions to dismiss, and in doing so, let the claims, many of the claims, go forward in modified version, modified formats. So basically, after this, there's a little bit more incentive for the corporations to kind of get this off the docket because these things are moving along in the process.
Right.
So we talked about how this is a group of consolidated cases. I think we have cases from like 19 different states. I think there was over 1,000 cases pending, and I don't know how many of those are consolidated here, but it's big, right?
It's big.
And there's a ton of legal claims that these schools are making.
Right.
They're alleging violation of privacy laws, consumer protection laws, laws related to children's technology use. There are also claims based on negligence, public nuisance, product liability, you name it. There's a lot going on here.
Wow.
The claim I want to unpack today is the negligence claim.
Okay.
Negligence basically is just arguing that you didn't act like we would expect a reasonable person to act, and that
caused harm.
That caused harm, right?
Right.
And so all of this is playing out because these social media companies, as I mentioned, moved to dismiss these complaints. And so the court is deciding those motions to dismiss at this stage.
Okay.
And the social media companies have a lot of arguments. Before we even get to the merits of the negligence claim, they've got a lot of arguments about why none of this should move forward and it should all get dismissed.
Yeah. Is one of those arguments the Shaggy defense? Oh, it wasn't me.
A little bit, yeah. It goes to this question of like causation.
Yeah,
like, are we really responsible?
Yeah. Shouldn't it be you parents controlling the?
Shouldn't it be you users who post content on the platforms? Shouldn't it be you children who are using the platform,
Right.
or shouldn't it be you parents who are responsible for what your children do online?
Right, because in many of these similar cases, basically what they're saying is, hey, we just set up the site. We don't create the content.
Yeah,
right.
We built a bulletin board. You put stuff on the bulletin board.
Exactly.
It's the people who posted, and that's actually one of their big arguments. So there's a federal law called, ready for this? Section 230 of the Communications Decency Act. And so, it's a federal law.
Okay.
It was from kind of early days of the internet, and it basically says that these platforms aren't legally responsible for what their users post. So it's exactly that argument. And it basically, we didn't want like hosting sites to be in trouble for the things that their users do, right? Because it's the users who are ultimately responsible for what they say on the internet. And so the social media companies are arguing.
If only it were that simple. Like that's, and I think that's the big thing here is like if it were that simple, it probably would not be an issue, right? Like, but what the plaintiffs are alleging here is that you're not just doing that.
Right.
Right?
You did more than built a bulletin board. You built a bulletin board that shouts at me and never ends.
Yeah, and only shows me things that are going to. It
drive
doesn't
my
show me
engagement.
everything. Yeah. I don't get to just pick and choose what I see. Right. So it's complicated.
It is, and so the Section 230 argument, like basically, it does limit kind of the potential liability here because it can't. The companies can't be liable for the things that their users post, but the court drew a distinction and said you can be responsible for the design of the platform itself.
Okay.
Right. So that your intentional design choices about how you deliver that content or what the product does. So like push notifications, all of those kind of like design features.
Right.
Those are things you can be responsible for. There is a question about like the algorithm, like which things it decides to push.
Okay.
And that I'm a little bit fuzzier on, but it seems like that is either covered under Section 230 or, importantly, the First Amendment. So that's another one of their counter arguments.
I'm more familiar with that one than
as you should be. We talk about it a lot. And so the companies are also arguing that how they deliver and organize content is protected under the First Amendment because it's speech, right? Okay. So like they're basically choosing, through putting it on their platform, they are speaking through these other users.
Interesting.
And so their algorithm is essentially speech because it's choosing which speech to promote.
Yeah.
And the court pushes back here too, explaining that, some aspects of the content delivery may be protected speech, but many of the allegations focus on design choices, which is conduct, not speech.
Right.
So, the claims here are limited in important ways. So we can't really look at content, including kind of the algorithm stuff, but we can look at the design features of what the companies did to build these platforms and what effects that has.
Okay.
Yeah. So you can already see these things narrowing a little bit.
Sure.
So let's get into the heart of the school's negligence claim.
Negligence.
So, we've talked about negligence before. We've called it the...
I remember.
You remember?
I remember. It's the DBCDs.
The DBCDs.
Yeah.
Just like the ABCs, but
not.
But not. Yeah. Hey, it's dumb enough for you to remember it. That's my teaching strategy.
It's duty, breach, causation, and DBCD, and...
the most important one.
I don't remember.
Damages.
Damages. Oh, damages. Right. Money.
Yeah. You have to be hurt to bring the claim. Yeah.
Yes.
Yeah. So duty, breach, causation, damages.
75%.
Yeah, you got that. And so, that's passing. So damages is pretty easy. Like, were you harmed by this other person's conduct? Here, there's two really interesting questions that the court answers, which is there a duty, do the social media companies have a duty towards these schools to act in a reasonable way towards them? So basically, are these schools in foreseeable risk from what the social media companies are doing?
Yeah.
And then the other issue is that causation issue, which we kind of alluded to earlier, which is are these social medias the cause of the harm to schools such that it's okay or legally appropriate to hold them responsible for the things that schools are having to deal with?
Yeah. Well, I would say I have a very strong opinion about what my answer would be to those two questions. But
let's see what the
nobody
court says.
asks me
Yet. So starting with duty.
Yeah.
So this is one of those complicated things because all of these 19 states have different rules about, or different legal standards for what constitutes a duty under negligence. But even they all frame it different ways, but there's a key feature that essentially says so that the defendant's conduct, here the social media companies, has to create some kind of foreseeable risk of harm to someone like the person injured. So it's this foreseeability thing. Could you reasonably foresee that somebody like the person who got hurt would get hurt based on what you're doing?
Okay.
And, here the court relies on the Juul litigation. So that was the e-cigarette litigation. A bunch of schools and local governments sued Juul and basically said
not the singer from the 90s.
No, the e-cigarette.
E-cigarette.
Yeah, the vape pens. I don't think they were related. And so it's a pretty strong analogy for the claims made there because they were making public nuisance, negligence claims, same thing here. And that's probably not a good thing for the social media companies because that resulted in a massive I'm not sure if that was a settlement or an ultimate decision, but big deal for the company, right?
It was big.
And so
Juul, I don't think she was 90s. Maybe it was early 2000s. But
I'll take your word for it.
We got to listen. We got to focus on what's important here.
Right? Yeah. Obviously.
Okay.
Sorry. So here, looking at whether or not it was foreseeable for the social media companies to, anticipate that their actions would harm someone like the schools, the court says, yeah, that was totally foreseeable. You knew about the mental health impacts.
Yep.
You targeted schools.
Specifically.
There's a growing body of research about the harms. You knew the impact your design choices were had. And from all of that, it's very foreseeable that schools would have to be, dealing with the consequences here.
Right.
So yes, there is a duty of care that these social media companies owed to the schools.
Okay.
So that's step one.
All right,
We're
check.
good to go. And breach is always a question of facts. So we'll put that one aside until we get to the merits. Causation. Causation is tricky for exactly what we talked about earlier. So causation, in tort law, there's kind of two kinds of causation. There's what we call actual causation and proximate causation.
So it's almost like direct and indirect.
Pretty much, yeah. So actual causation is you did something that led to the harm happening. So if you've ever seen like a Rube Goldberg machine where you push the marble and then at some point it ends with a hot dog being flung onto a grill, that's actual causation. If you hadn't pushed the marble, the hot dog wouldn't have gone there.
Okay.
Proximate causation is basically, is it fair to ascribe the result to what you did? And so basically it looks at, is there some like attenuating circumstances that were beyond your control? Is somebody else intervening that led to the harm? Basically like, is it too removed, the action too removed from the ultimate consequence?
Is the hot dog too removed from the marble?
Exactly.
Yeah.
Right. Yeah, because I didn't know there was going to be a bowling ball dropping onto that seesaw to whatever. You know?
Right.
Yeah. And so actual causation, that one's usually pretty straightforward. It's the proximate cause
that's harder to,
that's hard, right? And so here the social media companies are arguing that like there was intervening third parties here that kind of break the causal chain. Users, parents, students, right?
Yeah, I'm gonna say that's a little bit of a stretch.
Yeah.
Yeah.
And similar to their Section 230 argument, their First Amendment arguments, they're also saying that, you know, the users, the people who posted the content, you can't hold us responsible for what the users said and did. So like all of those viral challenges that schools had to deal with during like COVID and like right after COVID and all that, it's like, whoa. Blame the bad actors on social media. Don't blame the social media companies.
Right.
And the court, for their part, kind of along your lines, they seem to align with what you were thinking. So maybe they did ask you. Or
maybe they're listening to Chalk and Gavel.
Ooh, that'd be fun. So the court says at this point, like, all we're looking for is plausibility because this is a motion to dismiss, motion to dismiss. And it's plausible here that the harm to schools was direct and foreseeable, and there's no kind of breaking of the causal chain. So, you know, it's foreseeable that schools would be harmed by the companies deliberately designing their platforms to foster compulsive use in minors at school. Remember, they're trying to get that critical mass at schools to promote their products. And, you know, all of that shows that, like, maybe this wasn't just foreseeable, maybe it was foreseen?
Maybe it was intentional.
Right, yeah.
I mean, because... Yeah, it's like you can't. I don't know. You can't turn around and say, you know, well, you know, it's not our fault because of what you're posting. You're designing platforms that that specifically, they're designed for those posts. Right.
And they're being pushed to schools to like create more engagement in the school, right? Because it's all geography based. And so the court says, like, you know, we're not going to hold you responsible for what it calls non-foreseeable third-party activities. So, like, the viral social media things, and those are also probably, you know, protected under Section 230 in the First Amendment. So all of that's out the window, but, you know, all of the other stuff that we already talked about, the design choices, all of that,
I mean,
like,
that makes sense.
That's fair game.
Yeah, that makes sense to me.
Yeah. So where does that leave us? You know, at this, like I said, this was just a motion to dismiss, so the cases are ongoing. But as soon as you lose that motion to dismiss, that kind of changes the incentive structure. Like, okay, hey, this thing has legs. Maybe now is a good time to start thinking about getting this thing off the docket. And, you know, it does kind of indicate that these schools are making legally plausible claims. Like, this is a legally plausible story. So there might be more to this as it works through the system. So, yeah, we'll have to keep an eye on it.
Yeah, because, I mean, just from some brief research lately, like, if you look up this case in social media, whatever the thing
your
is
favorite
called,
case name,
you know, like, I would encourage you to kind of stay on top of this, because we're seeing, like I said, they consolidate all of the, you know, the paper portion of the case where they're, like, you know, building the case and discovery and you know, sharing the reports and all that stuff. But then again, they send it back out to the individual lawsuits for those individual courts to decide on those individual cases. And a lot of those decisions have been coming out over the last few months. Some of them have been settled by the social media companies. So, or not, or by both parties, right? Like, you know, and in some of those settlements, the social media companies aren't necessarily taking responsibility. They're just paying money for this case to go away, right? But that in and of itself is kind of a
significant,
statement,
right? Mm-hmm.
right? And then there's some other cases where I think that the courts have ordered these social media companies to pay out millions of dollars.
Right.
So,
well, and this is only one set of lawsuits against these social media companies, because there's also like social media addiction cases that individuals are bringing against these, and
that aren't part of this thousands.
Right. And that's like the users bringing claims. So there's like, I would not want to be an attorney for a social media company right now, because it sounds like they've got a lot of work cut out for them.
Oh boy, man. Yeah. So I think like the next year or so is going to be very interesting to see how all of these cases play out, because once you get kind of a critical mass of decisions,
right,
that's when you start seeing changes. And even if a lot of those decisions don't necessarily involve admission of liability and stuff like that, we talked about this way early on when we started talking about this case, that it almost doesn't matter what the outcome is from a legal standpoint if there's enough of a PR kind of like if the news organizations pick up on all of these settlements and they push it out,
legislatures,
right? And legislatures, right? You would potentially see a lot of movement in terms of policy and potential changes in how these social media companies operate.
And that's what the schools are kind of asking for. Like, and that in many ways, these lawsuits were a plea for help. Basically, the school's saying, like, look, we are drowning here because
exactly.
we are responsible for all of these harms, and we have to deal with them when they come through our doors.
Yeah.
And so, like, please, we just need some help.
Right.
And you know, that to me is one of the big kind of takeaways. Is like, you know, this is a really complicated case. It's a complex situation. There's no clear lines of responsibility.
Right.
It's messy. But, you know, schools are in a familiar position. The law is still trying to figure out who is legally responsible. Schools are managing the day-to-day consequences. And, you know, they're doing what they can with what they've got. But this is one of those mechanisms to, like, maybe we can get a little bit more help here.
Yes. And I don't know. I would like to be optimistic and say that based on what we've been seeing lately, I am hopeful that when all of this is said and done, and look, it might be years before that happens, but I'm kind of hopeful that schools will get help, the help
and
that they need,
we'll
in some
figure
form.
out a solution for young people's social media use, and like
and maybe not a solution, right?
Well,
but like improvements. Right?
Some maybe middle ground, or like something where we can address the harms, keep kids safe, you know, don't infringe on liberty rights as much as we can, all of that. And like, there's so much going on here that it's going to be a process, but that's what Chalk and Gavel is for.
That's right.
As we said in the bell ringer.
That's why we're here. To keep you posted on all this stuff. So, well, there you have it, folks, right? So let's talk about the homework.
So your homework, and yes, I recognize the irony of this, is to get on social media and like, rate, review, and join the conversation about Chalk and Gavel. We'd love to hear from you. If you've got ideas for episodes we should do or cases we should cover, let us know. Join the conversation. You can also go on our website, check out our merch, check out our episode databases, use it in your classes, in your professional development, share it with a friend, tell your plumber about it, whatever it might be.
Plumber.
Yeah.
Okay.
Yeah. And thank you to Andrea Morris, our new research assistant, for all of her help in getting all of this together.
Yes, thank you, Andrea. And a huge shout out to the Martha McCarthy Institute.
Right, which is why we're here in beautiful Bloomington, Indiana.
Yes, beautiful Bloomington. We're here for the annual Martha McCarthy Institute, and the Martha McCarthy Institute at Indiana is an incredible organization with incredible people.
Trying to increase educator legal literacy,
which is what we do.
Something we can get behind, right?
Yeah, so they are huge supporters. We thank them tremendously for all of their support. It's a great organization. So check them out, and then maybe in 2027 we'll see you at the Martha McCarthy Institute in Bloomington. So that's it for today, and we will see you again in 2 weeks. Have a good one, everybody.